Hi there, and welcome back to another episode of Divorce Well in Florida with Fairway Law Group. My name is Matthew Waring, and I'm a partner shareholder here at Fairway Law Group. And today we're going to be talking about high net worth divorces, what they are, why they're different, and what somebody needs to do to go about getting divorced when they think that they are somebody that might have a high net worth divorce. The first thing to understand is that all divorce cases in Florida, whether they're uncontested, simplified dissolution of marriage, regular divorce, high net worth divorce, doesn't matter, they're all going to be filed in the exact same court. That's going to be in the circuit courts in Florida, and that is going to be dictated by the county that you're in. Regardless if you have a $10 million marital net worth or if you have a $10 marital net worth, you're going to be filing in the exact same court. It's the same laws. It's the same procedures that apply. You're in front of the same judges. So there's no distinction. There's a lot of things that are different between a high net worth divorce and a regular traditional divorce. But I think probably the biggest distinguishing factor between them is that with a high net worth divorce, you might need a team of experts involved. And that can be more expensive, but there's reasons why you'd want a team of experts, and I can explain that. High net worth divorce doesn't just mean what it sounds like. It doesn't just mean that you've got a lot of money or that the marital estate is very valuable. If you have $10 million, but it's all in a brokerage account, or it's all in a 401k account, or it's all tied up between a marital home, an investment property, and a savings account, that case is going to be pretty easy. That is not what we're going to consider a high net worth divorce, even though the marriage is high net worth. It's not very complicated because you have a marital home that you're going to split. You have an investment property that was purchased during the marriage that you're going to split 50-50, whether by sale or one person buying the other person out. And then you've got an investment account, which is very easy to divide. Even if it's a 401k, we can get something called a QDRO in place, a qualified domestic relations order, which will bifurcate that 401k account depending on what you negotiate the split to be. And that court order will allow the investment company to bifurcate those accounts, your name on one of them, your spouse's name on the other, and then there's no taxable event. You don't have to liquidate that account. So that's really good from an asset protection standpoint. But those cases are not going to be that difficult. Those are pretty much the same things that go on in every case, whether the marital estate is worth $200,000 or $2 million. It's really the asset mix that we're concerned with. Typically in your high net worth divorces, the ones that we would consider high net worth or high asset divorces are going to be divorces that are involving businesses, business interests, complex trust situations. Those are going to be cases that require a team of experts. You might have multiple residential or commercial rental properties, and all of those things need to be valued. They need to be appraised. So we might be needing to hire or recommend hiring property appraisers. There might be businesses that need to be valued. If the business was started during the marriage, it's going to be a marital business. And unfortunately, whether you like it or not, your spouse is going to be entitled to half of the value of any business that you started during the marriage. Even if it's not a solely owned business, even if you own 30% of a business, your 30% stake needs to be valued. So there needs to be a valuation done of the business. And the thing is, these judges, the court system, the law, does not take your word for it. The courts do not ask you, hey, what do you think your business is worth? And you put a number out there and the court says, okay, cool. That's the value of the business. It does not work like that. The court is going to need proof. If you're the business owner, you're going to need to offer evidence that shows what you believe the value of the business to be. Your spouse, who's claiming 50% of that business interest, is going to have to present evidence of what they believe the business to be valued at. And in order to present that kind of evidence, you're going to need an expert to testify. There's going to have to be an expert business appraiser, somebody that's maybe a CPA, maybe they're a business broker. There's somebody that deals with buying and selling and valuing businesses as a day-to-day part of their job. And they're going to have that, you're going to have to establish in court that this person is in fact an expert witness and has the requisite criteria in order to provide a sound opinion. So when we're dealing with kind of high net worth divorces, high complex divorces, you're really looking at having expert witnesses, property appraisers, could be residential, could be commercial. A lot of those people don't appraise residential and commercial. You might need two different ones. Business appraisers. You're going to need access to the books of the business. You're going to need to get the QuickBooks account login. Both spouses are going to get that. They each have an equal opportunity to go in there and do some discovery. If it's a business with items, you're going to need to do inventories. If it's a business with valuable intellectual property, that intellectual property might need to be appraised and valued, and that might be outside of the purview of the standard business appraiser. You might need to get another expert to evaluate specific types of property held by the business. For example, let's say it's a construction business that owns a lot of heavy machinery. The business appraiser might be able to look at the books of the business, look at the revenues, look at the number of employees, look at the existing contracts, and be able to assign a value to that business. However, that appraiser might not be able to put a value on all of the heavy machinery that's owned by the company. That might need to be another appraiser. So when we're dealing with high net worth, complex divorces, we're talking about having a team of experts involved. So it's not just the lawyer. You're probably going to have a forensic accountant, a business appraiser, a residential appraiser, commercial property appraiser, and that's just on your side. Your spouse is going to need to do the same thing, is going to need to hire the same experts. So you're talking up to 6 to 8 experts who might testify at a trial in order to really try to get things done right. And it doesn't mean that your case is going to go to trial, but a lot of those appraisals and things need to be done prior to any settlement negotiations or mediation. You want to do the due diligence, especially if there's a lot of money on the line. If there's a very valuable business owned within the marriage, it's going to be very important to do that due diligence up front, because you really got to make things simple. If you're going to go try the case in front of a judge, you got to have your experts lined up. They have to have access to all the information they need to make their opinions. If they can come to court and make opinions on the value of a business, but the other lawyer can kind of pick apart their opinions, oh, well, you didn't take account the value of the heavy machinery owned by the business, so your valuation is wrong. Well, then that expert's testimony is going to carry a lot less weight at trial. So these experts need access to a lot of information. They might need to visit the business. They might need to speak with employees. They might need to review contracts. There's a lot of work that goes into valuing businesses and business assets, and also, to a lesser extent, residential properties, commercial properties, and that sort of thing. The other thing that can make high net worth divorces a little bit more complicated is, let's say the couple owns a lot of rental properties, and they're typically going to have each of these rental properties held by a different LLC. So let's say they have 6 different residential homes that they're renting out. They've got 6 different LLCs. Well, guess what? Part of your mandatory financial disclosure, you're going to have to produce the lease agreements for those 6 properties. You're going to have to produce 3 years of tax returns for each of those properties, the operating accounts, the checking accounts for those properties. If there's mortgages on them, mortgage statements for each of the properties. All that information has to be developed inside the divorce case during the due diligence period in order to actually put a value to some of the assets and be able to actually know if you're getting a fair deal in any settlement negotiations or at mediation. So those are the things that kind of make it different. Like I said earlier, you're really just dealing with maybe a marital property and some 401k accounts, some savings accounts. It doesn't really matter how much the value is. We're really looking at more of the asset mix of things. Something else that kind of goes into what makes a high net worth divorce different is standards of living. You've got maybe one spouse who's the breadwinner, and you have the other spouse who was maybe stay-at-home mom, for example, for many years, and they might still have young kids, they might not. So you're also dealing with alimony considerations. But you also deal with alimony in traditional divorce cases too. Even if a breadwinner is making $80,000 a year and the spouse is a stay-at-home mom, you're still looking at an alimony calculation. You're still looking at alimony analysis as being part of that case. However, it gets different when there's a lot of assets, when there's a high net worth, because it's a little counterintuitive. But having a higher net worth divorce might actually mean that there's less risk of paying alimony, not more risk of paying alimony, because alimony is based on not only the incomes and not only on the standard of living, it's based on one person's need and one person's ability to pay. So if the spouse that isn't the breadwinner is receiving, as a result of equitable distribution in the divorce, let's say $5 million, could be in assets, could be in cash, could be a mix of both. But if that person's receiving $5 million, how can they show that they have a need for additional monthly income? So it gets very difficult. They can prove that maybe their spouse is making $1 million a year and they're making $0 a year, and therefore they need a lot of alimony, right? But if they're receiving $5 million in a different mix of assets and cash, that money invested over time, they're going to be multi-millionaires if they handle their money right. So why do they need additional alimony? So alimony is factored in after equitable distribution, not before equitable distribution. Those are certain things that you want to make sure that are done right in any kind of complex or high net worth divorce case. You really get what you pay for when it comes to the due diligence period and the mandatory disclosure. If you cut corners with the due diligence, if you cut corners because you don't want to hire the experts, you shouldn't be shocked if you get a deal that you ultimately agree to because you don't have all the information and it ends up being a bad deal or what you consider to be a bad deal. The only way you ever know if you're getting a good deal or a fair deal is if you know precisely what everything is worth, where everything is at. You've seen every single account. You've hired a forensic accountant. They've gone through, found any transfers of money. They can go through and find any accounts that might be missing that needs to be brought into the equation. If you don't do that, you don't know what you're leaving on the table. So that's what's really more important. So with a lower net worth divorce or just with a regular divorce, there's less risk that you're going to be leaving a lot on the table because there's just less accounts. There's less complexity with respect to the financial accounts, business ownership, that sort of thing. My partner has talked on another podcast recently about things like RSUs and restricted stock units and contingent income, contingent stock if you're a member of or even an employee at a private company. And so I'm not going to get into that right now. But another thing to be concerned about is even if you don't have a marital business, even if you started the business prior to the marriage, it's your business, you own it, you started it 3, 4, 5 years before the marriage, but you've been working in that business for 20 years during the marriage, and that business has grown significantly in value. The appreciation on that business from the day you got married to the day you're filing for divorce, that value could also be considered marital, even though the business was premarital. And the reason why, and the way the law explains it, is you had a spouse that was contributing to the household, whether or not you agree with the level of their contribution or not. The way the law views it is that you would not have been able to work that hard in the business if you were at home taking care of the kids. So there's other kind of considerations involved. So even if it's a quote unquote non-marital business, a business started before the marriage, you still might have to provide at least some value of that. And that value, that portion that is considered marital, is often going to be in dispute. And that also is going to require a team of experts in order to kind of nail down, especially if your spouse is claiming that they're entitled to 50% and you're going to claim that they're only entitled to maybe 20%. You got to have the facts to back that up. You got to be able to explain why. Because if you're not able to explain why, what's the judge most likely going to do? It's different in every case, and I can't predict what judges are going to do. But if it gets very difficult and the judge can't decipher who's right and who's wrong, what's most likely to happen? An even 50-50 split. So if you're looking for anything other than 50-50, if you want to retain more of the value, you're going to need to prove how and why. When it comes to a business inside of the marriage, a lot of times the way a business works, the business probably cannot operate without you, without your input. If you're the business owner, if you're the main one working in the business, maybe you have the contacts, you have the business knowledge, So the courts really aren't interested in dividing shares of a marital business. So the court, they don't want to say, let me give 50% ownership to the spouse, you retain 50% ownership, and then after the divorce, you guys have to work together and kind of figure it out. That's going to set up people for a lot of fights, for a lot of problems, and that's not what the court system is interested in doing. They would much rather see that the person who operates day to day in the business retain 100% of the business after the divorce, but provide the spouse with 50% of the value of the business. And that can be done by shifting around in some horse trading of some other assets, shifting around some properties, bifurcating some retirement accounts, whatever it is, to make sure that the spouse gets at least 50% of the value of the marital business while allowing the business owner to retain complete ownership of the business. There's a lot of other ways that you can reach agreements. You could pay out that value over time on a monthly basis, which is different than alimony. You might work into an agreement for there to be lump sum alimony versus paying it monthly over time. And that lump sum alimony can actually take care of half of that business value. So you really have a lot of latitude with how you structure these agreements. And if the case were to go to trial, the judge has a lot of latitude with how they're able to structure things. But ultimately, what the court system is doing and what the law is doing is it's trying to reach an equitable distribution of all of the assets. So the best way to do that is to actually find and identify all the assets, properly characterize them as marital versus non-marital, and then actually value everything properly. And that oftentimes means retaining experts and a team of experts. So those are the main differences between a traditional divorce and what is considered a high net worth divorce. Getting these experts on board earlier, sooner rather than later, is usually the best thing. We handle a lot of these cases. When we get them, we outsource a lot of the work to experts right away. Our job as the lawyers are going to obviously be counseling people through the divorce process, handling the legal work, going to hearings, and forcing the other party to provide information. That's really what our biggest role is going to be, not only in presenting the case at mediation or at trial if need be, but in that due diligence period. If your spouse is not providing documents that the expert needs to value the business, we have to file motions, go to court, go to hearings, get a court order, forcing that person to provide the information. And that happens a lot in these cases. Whether we're representing the breadwinner or the stay-at-home mom, we're on both sides of these cases, so we know how they operate. But a lot of times what we're called upon to do is to hold the other party accountable and get all the information. And go to those hearings, get orders, and if they still violate them, pursue motions for contempt and enforcement, and make sure that we've got all of the documents, all of the information necessary to value these assets, to find hidden money, to find transfers of money, to find any other business interests that are out there that have not been disclosed. That's what we do. And then we provide all that information. We work closely with these experts throughout the case to develop the best possible arguments that can be brought going into mediation, and then obviously if the case doesn't settle, going into trial.